So what are the landlord rights according to Ohio landlord-tenant law? This is actually an important one if you're from out of state, or even if you're not from out of state, you might learn something. So a lot of times it seems like all the rights are skewed towards the tenant, and to an extent, tenants do oftentimes get the benefit of the doubt, especially in our legal system, like the actual decision-making processes. Sometimes the judges even go outside of where the law is and give them a few extra rights. So keep that in mind. At the same time, though, landlords do have some very specific rights according to landlord-tenant law. And I'm just going to be reviewing real quickly. There's a little pamphlet you can actually get. I'm going to post a link in the video description, as well as the blog post that this video is embedded in. And it's the Tenant Landlord Rights and Obligations, published by the Ohio Bar Association. So it's a pamphlet that is very helpful, and it's kind of like a white paper that helps you, give you a quick understanding of some complexities of the Ohio landlord-tenant law. So what are your rights as a landlord? First of all, as a landlord, you can rent your property for any amount you choose, okay? So there's nothing in the law that states that you can't, and so you can. It's your property, you can ask whatever you want for it. Now, if you're working with us, we're gonna be giving you some advice. And we actually advise you oftentimes to ask for more at first, but usually you get pretty quick indication on the market if you're asking for too much, because there tends to be a lot of activity with our marketing. So we can kind of tell you, hey, you're getting a good feedback from the market. And so obviously, one of the landlord rights is not that you can force someone to sign for the amount you want. You can only ask it and hope someone agrees to it. You can also dictate, obviously, just about any of the terms of the lease. There are some things that you probably cannot ask for or require, or at least if you do, it won't be legally binding. I think one of those things, for instance, is like a clause that says you can't defame me or you can't ever sue me. That's probably not going to fly in court. You may choose to rent to anyone you wish, and establish any conditions and terms in a rental contract that do not conflict with state or federal law. And probably the biggest one on that, so in terms of choosing, is that you cannot violate any of the anti-discrimination statutes. So for us, we do help you with that process, because we have a very specific screening process where we go through, and there's actually another video I do on this, where we actually do a screenshot of the checklist we go through. So you want to be very careful to stick to just the things that you're allowed to grade on. So you can't grade on specifically the protected statuses. And those statuses are expanding all the time. There's certain states, and I don't think Ohio's done this yet, but it's probably coming, where they're very limited even on criminal stuff. So they start to look at being a criminal almost as a disease, and then that gets interpreted into the ADA, the American with Disabilities Act, which then makes them a protected status. So that's probably what's coming eventually. That being the case, you can oftentimes make a case on things like credit. You look at the credit, and is someone who has extensive criminal history and makes lots of bad decisions all through their life going to have good credit? Probably not. So that's the way you get around that. And by focusing on the numbers and focusing on things that are not subjective and are not value judgments, you can still make a good decision as long as your house is a nice enough house to attract good tenants that you can then choose and screen from. You may evict a tenant for non-payment of rent. So it's funny because a lot of owners are worried, like, well, can I evict a tenant for this or evict a tenant for that? But he's in a lease. Well, yes, just because you're in a lease doesn't mean you can't evict a tenant for not paying. That's why you would do evictions. So regardless of how long their lease is and whether you've renewed or not and things of that nature, if the tenant's not doing what they're supposed to legally and contractually, whether they're damaging the house, not paying the utility bills, not paying rent, and by the way, our lease specifically says that non-payment of utility bills is the equivalent of not paying rent. Utility bills are considered to be rent for the purposes of our lease. So that's one of the clauses we actually have, and we actually do offer, if you look on our website, a free lease and some highlights of some of the important sections of our lease via video. Another thing, another specific owner right or landlord right, and I already kind of alluded to this, but if a tenant's violation materially affects health and safety, you must notify the tenant in writing and give the tenant 30 days to resolve the problem before filing an eviction. So in regards to filing that eviction, there's a specific process, but as long as you follow that process, you can evict them even for non-money related things. Also, a very specific right that is extremely specific, it can't be interpreted out or gotten around by the tenant, is that you have the right to access with reasonable notice. And reasonable notice is considered to be 24 hours. That's the way it's defined in the Ohio Revised Code. So as long as you give that notice, and the way that you give the notice actually is not really specified. So you can give that notice via email. And usually if you do, though, it's best to also make a call so that you can prove that they couldn't have missed that email. You call them, let them know that you gave the notice via email. That way you have multiple proofs. Then you give that notice, you can enter, as long as you give 24 hours, okay? And there are some caveats to that, like you want to be careful that what you're doing is not considered to be intimidation or things of that nature. So if there's already some dispute and you're getting ready to evict, you have to be a little extra careful because you're already bringing the law and the legal system into, and that could be called into question. But in general, as long as you have a valid reason for entering, and that could just be an inspection of the property to make sure it's not damaged, you can go in 24 hours. And that actually, it's not written here, it may be somewhere else in this white paper. In the case of an extreme emergency, you can enter the property without a 24-hour written notice. However, you do need to demonstrate the fact that there's going to be extreme damage to the property or potential damage to health if you don't go in. Like an example would be a gas leak, or you get notice from a water company that there's 1,000 gallons of water just went through your meter in the last 24 hours or something. Then obviously you could be looking at serious property damage. You need to go in. You have the right to have your property returned to you in as good a condition as when the tenant took possession, except for ordinary wear and tear. And of course, that's not as clearly defined as we'd like. There's a lot of opportunity for dispute. But part of what we do for you is when the tenant moves out, we make specific accounting where we make a judgment. We look at any damage and make a judgment of what is ordinary wear and tear and what is not. And so we take videos, we take pictures, and then we have a specific estimate of total repairs, and we say this percentage of we think is tenant repairs. And that can be open a little bit to negotiation. So we normally kind of negotiate high to the furthest we think we might be able to prove. And then if the tenant's really negotiating with us, we may come down based on our judgment. Hey, we might have a little hard time justifying this one or that one. We may come down a little bit because we make a value judgment. Is it, do you really want to defend this in court? And if you lose in court, pretty much the automatic repercussion for you is that you'll have to return double the deposit, no matter if you lost over a $50 item or not. It could be like $50 that you wrongly. So that's one of the reasons why we negotiate on your behalf on that move out process and try to make it reasonable on all sides so that you come out ahead. So in addition to your rights in the landlord listed here on this right here, there are other rights as well. Probably the biggest is that you have a bundle of rights just by owning your property. And some of those are given up. So you do have right to the title and deed. You never transfer that to the tenant, but you do transfer obviously right of access to the tenant for the period of the lease. So that's one right you actually don't have, which, well, you kind of have it, but you've transferred the use of that, or the fullness of that right to the tenant. So I hope that's helpful. And if you have any questions, be sure to comment in the video below, or feel free to give us a call at the office. My phone is 440-427-0123, extension 116.